Repetition stands allowed. Corrections are
Mentions.
Right, please, Your Lordship.
yes.
If it is filed by the respondent number 2 in item number 3, my lord,
Okay.
may kindly be allowed to call for, my lord.
Okay.
And,
Yes, Your Lordship.
Maybe taken up
Ah.
after receiving.
Maybe for listing of a criminal petition, Lordship, prior to 2019. This is a 2018 matter. On 7th, if it is possible, Lordship.
7 not
Or
possible.
14th, Lordship.
After 10th,
14th.
not 14th. We'll get it listed on which year?
2018.
You just meet the registry. I have given them instruction. Just why this matter is not listed. What is the subject matter?
Lordship, the charge sheet was filed without obtaining necessary sanctions. Stay is there, Lordship, but MACPs have been denied. So
No, wait for some time. See, we are here 2013 matter. We slowly we want to clear all this. Wait for some time. Not today. Today is the day one. Let us understand how we'll proceed. Make us some plans. Okay. You repeat your prayer on Friday.
Okay. Deeply.
May please, Your Lordship, I wish to mention item number 11, my lord. It will
Hmm.
be from next week, my lord.
Huh?
Next week, my lord.
Why?
My lord,
Why this matter is listed?
my lord, hearing matter.
This is for orders.
Others, matter.
Why should we adjourn? No, adjourn. Orders matters don't seek adjournment.
We'll see. Rest.
With item number 9.
Just a minute. We'll take Adar Misha goes, but just wait for some time because we'll conclude. We'll proceed. Let other order matters be completed.
10.
Yes.
Lordship, this is the appeal against conviction, but by this time, the appellant accused has expired. Now, the death report has already received as per office note 17/9/23.
So it
and
appeal
Lordship-
stands abated
Yes,
or
not abated because it is a conviction is only fine. So it is not abated. So that is why we had filed earlier two cases, IS, one for condemnation, there are some delay, number one. Number two, for substitution of his illegal. Yeah. So
okay.
both
Where is
have-
those application
Both have been already allowed.
allowed? Where do you get it?
On 21/12/21. One is 197, one is 196.
Okay. In view, registry is to correct the cause title of the present appeal in terms of this court's order dated 21/12/2021 passed in IA
196.
criminal number 196 of
Yes, yes.
2021. Full stop. and list this matter for hearing. When? This is a matter pending since 2012.
12.
Huh?
12.
What is the conviction here? List this matter for hearing on given date. This matter for hearing
I know, only fine.
November, no? On 19th of November, 2024.
Merciless.
Seven.
Yes. Also kindly print the last order in borrow 12, 12 and 18 minor.
Hmm.
So that minor LCR was called for after. LCR received minor. Let the matter be fixed for hearing minor.
As LCR has already been received, list this matter for hearing on 28th of November 2020.
28th of August. As per office note 18-9 minor.
Hmm.
Await service report awaited.
What were the offenses?
Malad here conviction under 324 Malad 2 years.
324, is it necessary? Informant,
That is as per notice man.
huh? Is it necessary as on date? What losses? Huh?
Perhaps not necessary. Malad
No,
320.
not perhaps, but our extent norm says.
Hmm.
Whether informant is necessary in all cases. What do you say? Yes, Mr. Mahajan. Whether as per High Court rules
Hmm.
and that judgment, informant is a necessary party in all the cases.
Fine.
In criminal appeal.
Fine.
Or necessary.
Not in all cases, in
Mhm.
specialized acts,
Not in all
possible,
cases. So
possible.
therefore, this 323, 324.
Fine.
Informants present, it is not a necessary party, but informant will have or victim will have a right to participate.
Exactly.
This is the proposition
Absolutely.
law.
Absolutely. There's a proposition of law, my lord, it does statute also.
And thereafter, our High Court rules was
Yes.
also amended, a division bench judgment,
Yes,
is not it?
yes.
What is that? Full stop. Steps upon the respondent informant has already been taken. Full stop. Is in terms of extent norm. In the present appeal, the informant is not a necessary party. LCR is received. LCR is received. Huh?
LCR.
In this matter, LCR has already been received and matter is pending since 2012. None appears for the appellant on call. Give a amicus list, amicus juris list. Single bench amicus list. List this matter for hearing on next day, 21st of November 2024. Registry to Mr. Swenso is appointed as amicus in this court case. Registry to furnish the records / papers to the learned amicus and list this matter on the next date fix, reflecting the name of the amicus. Yes. Mostly mind it, huh? 19th, 20, 21. 3 matters we have fixed on hearing. Prepare a separate hearing list. Will not adjourn all these matters. Yes. Yes.
May please your lordship.
Yes.
As per office note dated, LCR has been received. Kindly matter may be fixed for hearing lordship.
This matter is ready as regards record. Accordingly, list this matter on for hearing on 22nd of November.
No.
এটা এখন calendar আমার। Yes, Mr. Kotogi.
My lord, in case of 14, my lord, he expired, my lord.
Uh,
Dilesha Datta, my lord.
now. What is to be done? Any report called earlier?
No, not earlier. It was not.
Any birth certificate, death certificate?
The death certificate is with me, my lord. But CBI is not here.
Where is CBI? This is item number. Who died? Item number
Item number 14, my lord.
14. And
Dilesha
what
Datta.
about 15?
15 is still there, my lord.
Okay,
So far as 17, he also expired, my lord.
17 also. What about 16?
I am appearing on behalf of
Six-
item number 16.
16.
LCR
So we'll
has been
fix this matter for hearing on 23rd. These matters are ready for hearing accordingly. List this matter for hearing on 23rd. On that day we'll decide. Huh? 23rd is a holiday? Huh? Okay, Saturday, then 25th.
20, it will be 26, my lord.
25th.
Monday.
This matter is for this bench will be for that only. To clean up,
Paperwork will not. That's
to
why.
make you people chamber clear, so that all these matters are covered with dust or removed from your
Now, what problem
almiras
is
and
here, my
drawers.
lord, Mr. Halloi appears for the appellant, man.
Hello is having any problem on?
No, he's appearing for the appellant, my lord. His name is shown in the appellant.
Maybe we do not know. If he arranges, it is there. Those will be not our lookout. We'll appoint MI and hear it. Yes, 25th or 6th. Tell us.
25th, my lord.
25th. Yes.
15.
None appears for the petitioner on call. Where is the amicus list?
18, 138 negotiable instrument.
Yes, what is the status here?
18.
Yes, madam.
Lordship, we may be allowed to take fresh steps, Lordship, within 1 week.
Steps upon whom?
Respondent, Lordship.
138 NI Act, my lord.
But respondent has not appeared.
Not
Is
Take-
there any stay?
not taken any step, my lord. They, as per
Not yet.
my lord.
Step, Lordship. 1 week time may be given, Lordship.
No, we'll close it for want of steps. What is the present status? Is there any stay?
As per officer 2018, my lord. Office number. Eighteen.
Though this appeal was admitted way back on 22 to 2019 and a direction was issued for taking steps and subsequently to take fresh steps. No steps has been taken till date upon the respondent. Number 2. Full stop. Upon the respondent number 1. The learned counsel submits that she may be granted, she will take the steps during the course of the day. In view of such submission, matter stands adjourned, enabling the petitioner to take fresh steps upon the respondent number 1 during the course of the day. If no such step is taken, this matter be listed once again day after tomorrow. Yes, next case.
18,
20 also same. No, no, no.
This was 19 only, 18 only, 19. None appears for the appellant on call. Yes, Sharma, this is a local.
My
Is
lord,
this,
item 19, my lord. Here we are not party here, my lord. It is not party.
no, you are not a party, maybe, but there is an order to obtain a report from the OC
My lord.
in respect of service of notice upon appears for the petitioner on appellant on call. Look, just look into this file.
My lord. If required, my lord, I will take instruction from the OC.
No, no, there is something is on record. They said you are. There is no you are, not you are.
My-
None appears for the appellant on call. None did represent the appellant on earlier occasion, that is on 12/3/2020. Service report of notice upon the respondent is not received from the officer in charge of the concerned police station. In view of the aforesaid, Laojima Court in its earlier proceeding has directed the appellants to take fresh steps for service of notice. However, no such steps has also been taken. Yet what is to be done at the cost of the exchequer of the state will issue notice
My-
and will appoint an amicus.
my-
And what happened to the lawyer who is so responsible? Will refer it to the bar council for misconduct. Prima facie view that this is a misconduct. Once a wakalatnama is accepted without formal thing, will not accept this. Will not close this matter at appointing amicus. Yes, Mozumdar, help us. Is it not a misconduct?
And I just lost may kindly repeat what. Yes.
This is an appeal.
Madam.
We cannot dismiss it for default. criminal appeal. Steps were directed to be taken, officer inserts through the officer inserts. Steps were taken, no report was there. Then thereafter, appellant did not appear either before this court, neither before this court, nor before Lajima courts when matters were listed at least on four occasions. And it was asked to take fresh steps. Now same thing happens today. Okay, we understand, we'll appoint an amicus at the cost of the state exchequer, we'll get it Xerox. We'll do it through the whole administrative mechanism we'll use, but what will happen to this lawyer? Can a person do like this?
Actually, give him one opportunity to clarify.
Opportunity to whom?
To him.
Through whom? Should we publish a notice then? So let the bar council say, let him explain.
My lord, since he's a member of this bar, lordship,
Everybody is a member of the
No,
bar.
what-
See the
what I'm saying-
situation.
notice of not required to be sent. My learned friend will inform him, and lordship may fix a date for clarifying the position. I'll otherwise argue, my lord, lordship may appoint me. But this explanation, lordship may kindly call for. If your lordship is not satisfied, then your lordship will refer to the bar council. Let him come and appear before lordship. He's a member of this bar.
We'll have to invite him.
My lord, it's better because my learned.
Let
No,
the bar council invite him.
I'm not saying
The
about
prima
everything.
facie, we are thinking that
Lord-
this is not absolutely irresponsible and misconduct. Our view, bar council may say, no, this is not misconduct, he might have explanation. Why should we start this proceeding here?
No, lordship may not initiate in proceeding. What I'm saying is.
We're just referring that this is our view, we are appointed so and so, so and so. So
I'm just in.
please this matter day after tomorrow. We'll see.
My learned friend.
Minor.
We will not say anything. Will not say anything. Will not say anything. But we are going to do this. It's not so casual. Somebody will accept a brief on somebody's behalf. You have all right to withdraw, write a letter, issue a notice.
I'll see.
This is not the way. At least in this court, this is first day, we will not, of this bench. From tomorrow onwards, this message should go, not only to this lawyer, to others also. Yes, next.
20.
Yes, what is this? Again,
Here again also no step, minor.
Steps to be taken also.
during the course of the day. And if no such step is taken, list this matter day after tomorrow.
Also, in this case, petitioner has passed away, lordship. I'll have to take instruction, lordship, whether they want to. or not. চলো, মুখ conclude করছি। Yeah, 145 proceeding. lordship.
See, this matter was listed on 22nd of April 2024 before this bench.
Yes.
Yes, Mr. Jha.
Your Lordship, in this case, the matter is fixed today. They file an application for substitution of the legal heirs of the respondent.
Ah,
Now the petitioner has already expired.
In the meantime, now petitioner has expired.
not petitioner, the applicant in
Applicant.
IA.
Applicant expired.
Petitioner is in the criminal revision petition. He has already expired, that we know. Applicant.
Applicant expired.
Now what is to be done?
Fix it after.
What will fix, who will represent? Secondly, right to sue survive. If the father is died, son is died, who will represent?
145 proceeding, so I will have to take instruction. lordship. Just 145 proceeding.
When day after tomorrow?
After a week, lordship.
No, not after it. This matter on Monday. It is submitted that after date of the original petitioner, though an application for substitution is filed by his legal heir, but the said applicant has also in the meantime expired. And accordingly, the learned counsel seeks for an adjournment to complete his instruction, whether complete.
This applicant was the first petitioner. Lord. Died, their party is died. Lordship.
Your lordship, in this case.
Okay, you respondent died, okay.
Respondent died. Now the applicant
Okay,
died.
not necessary. Just write it down. He submitted that during the pendency of this petition, what is the issue? 145.
145.
The present petitioner has in the meantime expired. Accordingly, the learned counsel for the petitioner seeks for an adjournment to complete his instruction. Prior sense allowed, list this matter on 11/11.
Oh, like.
There is some problem was there, then it was clarified, but then office is waiting for your lordship signal to send a notice. Everything is all right from our side, but then they are waiting that court should.
Okay, heard Mr. Mozumdar, learned counsel for the petitioner. Pursuant to this court's order, which was the order? Order dated 2/9/2024. An affidavit has been filed, full stop. In view of such affidavit, the affidavit let the registry. In view of such affidavit, the explanation given in the affidavit are accepted, full stop. Accordingly, registry, accordingly, the petitioner to take steps for issuance of notice upon the
On the steps we have taken.
taken. Accordingly, registry may do the needful for issuance of notice
To respond.
to the respect.
I pray for time being senior on legs and under God,
Review by
petitioner.
appeal was not entertained.
It was, with, on withdrawal, we withdraw. To file a fresh review petition.
List this matter next week. Give a date. On the prayer of the learned counsel for the petitioner, list this matter, give a next day. Don't- 24.
Your lordship, earlier lordship, your honorable court passed an order, lordship, on 25th.
Yes, sir. What happened now?
Nothing have been done, lordship.
Earlier, your lordship has directed the
That
government.
measurement and all.
Yes, yes.
That has been done.
That has been done, Lord.
Very good.
As per my instructions.
Ah.
Now the department is on the move that they are going to foreclose this project, Lordship.
Okay.
Since the land acquisition problem has arisen
Ah.
and department does not have the sufficient money to compensate the persons. So they have.
If you want free land, you can complete.
Not free land, because earlier we have received the land availability certificate from the
DC.
circle officer. Now they have U-turn.
U-turn.
Now they have U-turn and now they are claiming that this
So
is
we
a,
close it.
yes, we will, it's a foreclose.
So we'll also, they don't have any grievance.
Yes, yes.
Matarans there.
We have a homestead land, lordship, their lordship. and-
So they do not want your land. That's all. Your whole apprehension and we pass the stay order on the ground that though it is an important public project, you are going to demolish your houses and all. They said there is no land acquisition is required. Deputy Commissioner says land is required.
Required.
So thereafter we said, okay, finalize it, whether land, public land or private land. Then they could understand that it will involve acquisition of private land.
Private land.
And therefore they have abandoned the project. Your
Yes.
property is safe.
Or then lordship, some instruction is required from.
What instruction is
from the
required? I do
petitioner,
not
lordship.
understand.
Otherwise, if lordship without.
So there is no meaning of IA also.
Yes, Lordship.
Mr. R.M. Das, Learned Standing Council
Water-
for the
Water resource.
Water Resource Department submits that the project which was proposed by the Water Resource Department has already been abandoned by the department for the reason that the said project will require sufficient money for compensation of affected landholders, in as much as it was initially certified by the revenue authority that land shall be available without any acquisition and free of cost. In view of the aforesaid stand, in the considered opinion of this court, nothing shall survive for further adjudication, inasmuch as it is the grievance of the petitioner that their lands are being taken over without due process of law and without paying compensation. Yes, we'll close it.
I just lordship consult with them, lordship.
What
If lordship
consultation?
they repair the road, lordship, then lordship,
She wanted more. Now they said, okay, we will not give you anything. Now you are unhappy. Why they are not doing that project? Problem is there. List this matter day after tomorrow. At this stage, the learned counsel for the petitioner submits that he may be granted a day's time to complete his instruction in this regard. First, prayer is allowed. List this matter on today is 4th, 5th, 6th.
I'm extremely sorry. Item number 19. They have already sorted out the issue. This matter pertains.
Who will pay the cost for wastage of time of the court?
Because there is no communication. Repeatedly, I'm communicating with the client, but they are not conducting.
That you should tell
But
to
the
this court.
concerned counsel who is conducting the matter, I
Ah.
communicated with him yesterday only.
The
And he has
learned, what
informed
is
me
the
that
item number? So we'll close it.
the check bounce case,
Learned
she has
counsel
already
for
received the
the
amount.
petitioner. Mr. S.P. Chaudhuri submits that he has instruction to submit that the parties has amicably settled this matter and therefore this revision petition may be closed.
Appeal, lordship.
This appeal may be closed. Be that as it may, as there is no, as according to the learned counsel for the petitioner, no grievance remains accordingly, the criminal appeal stands closed.
All right, lordship.
Lordship, can it be on 11th, Lordship?
11th.
Lordship. Keep it.
That may earlier matter 11th.
11th.
Twenty.
Leave it.
Very helpful. Orders model first.
Item number 9, timing matter.
Yes, Mr. Bhattacharya. Just take your seat, take your seat. Yes. Yes, tell us.
My senior is on next.
No, I am asking the other senior to take the seat. When the senior is sitting here.
Oh, Lordship, he's next in court number.
No, we
5.
understand that is in legs. Today or some other day.
Yeah.
Yes, Mr. Bhattacharya, what you say? He's on legs. What is the stage of trial?
If it is going on.
He's on legs. Now, if we enter into other methods, it will take some time. That's why we thought that we'll finish the shorter methods and hear you, then we'll come to Mr. Mahajan. Huh?
On 7.
If you can excuse me on 7th, 7th and 8th. I might have some difficulty on these 2 days, some other matters. So if it can be on 11th, if subject to your convenience. Yes, 11th. On the prayer of the learned counsel for the enforcement directorate, the matter stands adjourned and be listed on 11th. Mr. A.K. Bhattacharya, learned senior counsel for the petitioner, is present.
Item number 1.
Yes, where is PP? PP or this Gogoi? Just wait for something.
Man.
Next case. Next. We'll do some other day. I'll also go through the affidavit.
In that case, my lord, after 2-0, my lord.
After 2-0?
Right.
Okay. An affidavit has been filed today,
Yes,
second.
fine. Saturday, last Saturday.
on Saturday, and which is brought on record today only. First up, the learned counsel for the petitioner, M. Ahmed, seeks some time to go through the same. Prayer is allowed. Please this matter on
After 21st, as you.
22nd of November,
No,
2024. Okay, we'll see what is his then. You also go through it.
but 22nd ki ase?
Provided to respondent.
Copy,
Friday
copy,
Friday nahi.
Respondent.
provided.
I'll provide it.
Okay.
Mala, 22nd is Friday.
Friday?
Next Monday, my.
Okay. Next Monday will be 25th. 25th. So she wants a copy. You give it to her.
Hey, the copy ta 26th of 27th.
27th. Okay. You give her a copy. Yes, next case.
I think private is one.
Respondent.
May I please, my lord?
Yes.
My lord, this matter, my lord, Mr. P. Sharma is the leading counsel, my lord. He already expired, my lord. We could not trace the file, my lord. Matter may adjourn, my lord. But sometime-
Nothing is there.
Admit, my lord, but sometime may give.
Your name is there in the concur and nothing is there.
Sometime may given, my lord, we could not contact client also, my lord. Sometime may given, my lord. What is his instruction, my lord?
May I submit, Lordship?
No steps taken. Yes.
It is a matter of 2013.
Ah,
Two courts has upheld.
concurrent. That's what I'm saying.
Lordship, kindly peruse the last 2-3 orders.
I have seen that.
No, Lordship, compliance of this honorable court's order.
Ah,
And since 2013, the respondent is suffering as their money was using by this appellate
Tomorrow?
lordship.
My lord, sometime may given, my lord.
no, sometime.
2 weeks, my lord, at least, my lord.
Not at all.
Check
1
this-
week, my lord.
Just be happy that we are adjourning it till tomorrow.
3 days, my lord.
No,
lordship.
nothing doing.
It's a case of
Tomorrow.
beneficial legislation.
Tomorrow. I can dictate right now. You go through it. Or if you say that I cannot argue, we are appointing an amicus
And tomorrow, my lord.
tomorrow. List this method.
Obliged, Lordship.
Question. Question. I'm here on behalf of Mr. M. Ahmed.
Hmm.
This matter will be fixed tomorrow or day after tomorrow, Lordship.
Why?
He's in lake, in court number 7, Lordship. It's an old matter, Lordship, that's I admit.
What is the present status?
Lordship, record is not with me, Lordship.
Huh? Okay. Make it, get it listed on Monday. Huh? Next Monday.
Mass of Lordship.
But come prepared, no adjournment. On the,
Yes,
the learned counsel for the petitioner press for an adjournment on the ground that he has misplaced the record. So this matter is pending since 2013. Therefore, this court is not inclined to adjourn this matter. However, as the petitioner counsel is not misplaced the record, as an last opportunity, matters prayer for adjournment stands allowed. List this matter on
Any day, Lordship.
11/11. Yes,
In 7, I'm for responding wife lordship.
yes.
And in 8 lordship, we have, the husband has filed a quashing petition.
Hmm.
Same order lordship impugned in both the petitions,
Yes, Argu.
lordship. Lordship,
Which is your petition?
my petition, 8 lordship.
That I have criminal petition number?
Criminal petition number 485 of 2017.
Okay,
The wife lordship
Hmm.
has filed
485.
85 lordship, 17. Lordship, she filed 125 application
Hmm.
before lordship law court saying that she is not living, both are not living together and praying for maintenance lordship.
Hmm.
Saying that her husband is ONGCL employee lordship
Hmm.
having sufficient income.
Hmm.
But present situation is that lordship, she's living in my house. I mean, my
But the
house.
husband.
I'm the husband.
Ah.
I mean, since she's living in my house, I'm maintaining her. I'm bedridden, lordship, 65, 66 years old now. I am in, I'm in need of money, lordship. She's living with me only. I mean, same residence. But in evidence,
So
lordship,
nothing is there. She is not coming also. We'll
so
close it
last-
that they are living together, they are meant.
together means lordship in same house. Maybe some quarrel was there, lordship, but she's living. He is
You are having
bedridden.
you are having your pension.
Yes, I am having him. I am maintaining the household.
But she is not here, so we'll dismiss your petition.
My
She will not go for execution. That matter is there.
no lordship. Let her come. One day may be given.
No day may be given. We are dismissing both the petitions, both the criminal
Okay.
petitions.
Both in case of both dismissal, I don't.
Both are, we are,
My petition may be allowed, lordship. Since
No.
I'm maintaining lordship.
we do not know. These are, we'll go by the, what is the evidence on record and whether within legal parameters we should interfere.
Records are isn't it? Records are there.
What record is required in a criminal petition? We'll go by the judgment, that's all.
Lordship, judgment, lordship in para 13. She's saying that I'm living in his house, lordship. Yes, page number 14, lordship, para 13.
What is the judgment?
Lordship, in session judge judgment, my petition, lordship, page number 17 onwards.
That can be a application under 127,
Lordship.
isn't it?
Lordship.
So we'll give you liberty to file application under 127. It is 125, isn't it? Maintenance. Then, so 127, you can very well say that nothing is there, we are living happily. So that there is a change in circumstances, isn't
Yes,
it?
change in circumstances.
So
Right.
127 deals with it,
Lordship.
isn't it? Read it, 127, isn't it? If I'm not mistaken.
CRPC.
Where the good habits have gone, you have come to argue a case of 125 and CRP is not with you.
No, lordship, yes. I'm extremely sorry, lordship.
Better be sorry. Good habits are gone. Yes, next.
Lordship.
Read it, 127.
Additional apology, lordship.
Yes. What it says.
126. इधर इसी पेज की टा alteration in allowance, lordship, on proof of a change in circumstances of any person receiving under section 125 monthly allowance for the maintenance or interim maintenance, or order under the same section to pay a monthly allowance for the maintenance or interim maintenance to his wife, child, father, or mother, as the case may be, the magistrate may make such alteration as he thinks fit in allowance for the maintenance of the interim maintenance, as in case may be.
Heard. MS. Spencer. Garnet Council. In criminal petition 485/2017. These two criminal petitions are taken up together, which arises out of a challenge to judgment and order dated order
6-3.
dated 9/3/2015, isn't it?
Initial order was 2015. The challenge is made lordship 6/3/2017.
Where
The
is
session
that?
charge order.
Where is that?
Page number 17 lordship.
Yes.
17 lordship. By which the
Okay, Silence or order dated or judgment order dated 6/3/2017 passed by the learned session judge at Jorhat, whereby the judgment and order dated 9/3/2015 passed by the chief subdivisional magistrate within bracket M Titabar passed in exercise of power under section 125 of CRPC was modified, isn't it?
yes lordship.
Modified, full stop. Criminal, by the aforesaid order, the original award of maintenance of rupees 15,000. What was the original? 15,000. 15,000 awarded by the subdivisional magistrate in favor of the wife was reduced to rupees 12,000. Full stop. The husband has preferred criminal petition number 485/2017 against what? You have challenged the original,
Lordship.
isn't it? That is what I was saying.
Lordship. Because it was 15,000 lordship.
You challenge the everything, not only 12,000. 12,000 challenge means this was
Only.
only. So you are not, are you having the brief?
Yes lordship, I am having.
Okay. কি করলো? The husband has preferred criminal petition number 485 of 2017 assailing the judgment and order dated 9/3/2015 passed by the subdivisional magistrate as well as subdivisional magistrate in miss case number 110/2012 as well as the judgment and order. Did you prefer any appeal against it?
No. They came before.
What is your challenge?
My challenge was the quashing of the order dated lordship, both the orders lordship, saying.
Why both the orders?
Because both the last lordship, the order.
You did not prefer any appeal against 15,000.
No lordship.
Then
She preferred.
see,
It was.
here was the, see if I can understood correctly. Initially it was 15,000
Yes lordship.
on the application of the wife.
Wife, yes.
Now you were never been aggrieved against that order.
She came lordship. I didn't came.
You were never there. Only on that count we will dismiss your petition.
Lordship.
Listen to us. Then she approached the appellate court
Lordship.
because this order is an appealable order,
Lordship.
isn't it? Now she preferred the appeal. In appeal, it was
Modified lordship, decreased by
See-
12,000. No, lordship.
no.
I appeal.
You preferred the appeal. That is
Yes,
it. You don't.
that is.
Okay. কি বলতেছে then? Then she preferred the revision here against reduction of 12,000.
Lordship.
Yes. Then question. No. To 12,000. No, 110/2012. Last line. Give me Order dated 9/3/2015 passed by the subdivisional magistrate in miss case number 110/2012, is not it? And the appellate order dated 6/3/2017 passed in revisional order, not appellate, revisional order dated 6/3/2017 passed by the learned session judge in criminal revision number 14 of 2015. Full stop. The respondent wife and the wife, on the other hand, by preferring criminal revision petition number 114 of 2017, has also challenged the judgment in criminal revision number 14 of 2015, dated 6/3/2017, passed by the revisional court against reduction of maintenance amount from 15,000 to 12,000. Full stop. None appears for the petitioner, that is wife, in criminal revision petition number 114 of 2017. Full stop. Though Ms. Swenso is present representing the husband in criminal petition number 485 of 2017.
70.
It is on record that both the husband and petitioners married in the year 21/4/1986 and alleging non-maintenance by the husband, the wife had preferred miss case number 110 of 2012 under section 125 CRPC. Full stop. The learned, the respondent, the husband also contested the aforesaid proceeding by filing written statement as well as by adducing evidence. After considerations of the material available on record, more particularly the deposition of the husband that his wife do not have any service or business, and considering the income of the husband who was husband, and also husband, income of the husband, that is his salary amounting to rupees 41,090 as an mechanical worker in Oil and Natural Gas Corporation Limited. The learned trial court awarded a monthly maintenance allowance of rupees 15,000 per month. Full stop. Such being dissatisfied with such order, the husband preferred the criminal revision petition as recorded here in above. The learned revisional court, after considering, reappreciating the evidence available on record, evidence on record, and also considering the income and expenditure, and also considering that the only source of income of rupees 40,000 is from of the husband is from his salary, the learned revisional court came to a conclusion that the reasonable quantum should be rupees 12,000 for maintenance of the wife. Full stop. Maintenance of the wife. Such decision though is challenged as recorded here in review, none is present to pursue such challenge on behalf of the wife. Therefore, this court will not enter into the contentions raised in the petition by the petitioner wife. MS Kanango, Learned Counsel, what is your argument? Submits that.
Lordship, she is living in my house. It is evident from her evidence, Lordship. And since she's living in my house also, I'm also maintaining her.
Submits that it is available on record that the wife is staying in the same residential accommodation provided by the petitioner husband, and the petitioner husband is maintaining herself, and therefore separate maintenance would not have been awarded. Full stop. Would not have been awarded. Where is that evidence?
Lordship, page number, it is evident, page number 14, para 13. In the instant
Staying in the same house, and the fact and a statement that the husband is maintaining herself cannot be only ground to allow the present petition, inasmuch as this is the second revision petition at the behest of the husband, full stop. So where is your ground in the
Lordship,
appeal that
revision, Lordship.
in the appeal you have argued that this is
Lordship, page number 7, Lordship.
Mm.
Then page number 8, Lordship, reciting page number 8, Lordship.
such materials that it is available on record that similar stand was taken by the husband during the trial as well as in the appellate stage, and contended that he did not made with cruelty upon his wife, and that he took utmost care of of his wife and 2 children. And it was his contention that he is not able to provide maintenance to his wife as demanded by her. Therefore, in the aforesaid concurrent finding, in the backdrop of aforesaid concurrent findings of fact, this court in exercise of 482, in exercise of power under section 482 of the CRPC would not like to enter into the concurrent finding of facts by the learned courts below, inasmuch as the appellate court only interfered and modified the amount of award and not with the findings of fact that the husband failed to maintain his wife. Full stop. In view of the aforesaid, both the revision petitions stands closed. Hmm? Hmm.
Item number 25.
Please, Your Lordship.
Hmm.
My lord, FIR is page, my lord, 21. Sorry, my lord. FIR is page, my lord, 22.
Page
22, 22.
Two.
Next for 8.
Please this matter before any other bench without me. I dealt with this matter that during the.
Highly obliged.
26.
May I please, your lordship.
Yes.
Lordship, although this matter has come up for hearing,
Hmm.
as per the order dated 8/6/23,
Hmm.
8 June 2023, a report was called for, lordship.
Yes, what is your instruction?
Lordship, no instruction, lordship. Based on the limited instruction that we had informed way back in 22 that the appellant has expired, lordship.
My lord, in this regard, my lord, as because we have not received any instruction from the end of the SP earlier, my lord, and to 2022 today also, I communicate with the SP along with the earlier order, my lord. He prayed some time, my lord, because earlier order when my lord passed.
Okay, okay.
Yes, ma'am.
The learned additional public prosecutor. But SP Lakhimpur has already forwarded, submitted a
My lord,
report.
that is submitted in 2022, my lord.
Ah.
And that order, my lord, reflect, that is the convict who
But
represent,
now he has went to Dhubri.
my lord, that is the
Now how the Lakhimpur SP will
SP,
find
my
him
lord.
out?
My lord. Because my lord, as per the Gaambura's report, that is
So
reflected,
he
my
is
lord.
no more there. How the SP, Lakhimpur SP will find him out in Dhubri?
My
Now
lord.
we'll have to give him a Dhubri SP. A Dhubri SP, from where will he find it out?
My lord, that is the problem. If my lord from
You
there,
can pass an
my lord,
order, but what would the SP will do?
my lord,
Because he has specifically reported.
my lord, that was reported, and that was also sent from the SP's end, my lord. 2022, that order I have gone through, my lord.
Why should he disbelieve the OC and Gaambura?
Medical certificate 9 Amazon.
নাই নাই তেতিয়াই গম পাইছিলো দুখাইছে তাৰ পিছত একো খবৰ নাই
তেওঁলোকৰ লগত ডেথ চাৰ্টিফিকেট থাকিব ন আপোনালোকে কমিউনিকেট কৰোঁতে দিয়া নাই
How will he trace him out, his family? There will be hundreds of Karamat, thousands of Karamats Ali in Dhubri.
My lord.
Huh? Okay. You give a concrete report since there is a judicial order.
My
We'll
lord.
just adjourn under. The learned additional public prosecutor, Mr. Spencer, submits that the superintendent of police Lakhimpur has prayed for some more time to comply with this court's order dated 8/6/2023.
My lord.
Prayer is allowed.
My lord.
Accordingly, list this matter after 2 weeks.
My lord, maybe 3 weeks, my lord.
After 3 weeks.
My lord. Deeply obliged.
Try to have it whether he can have some
My lord.
Dhubri counterpart.
My lord, when I saw the.
We'll not
the
go
order,
to
my
all
lord.
this, we'll see, but if we can have any link, then this matter, we can close it.
My lord.
May I please, Your Lord?
Yes,
On behalf of MK Das Legal Aid Council, for item number 27, Your Lordship,
yes.
I pray for an adjournment today.
Who is
He
for-
is there for 28.
Who is
Sir, I'm
28?
for 28.
Yes, Sargu.
I have to receive paper book, Lordship.
You have to receive paper book. Why paper book is prepared here, single bench? What is the direction to, who are you?
Tiberi,
You are, we know you know. Who are you? You are representing whom?
Vikas Sangma, Lordship. Second number,
Because
Vikas Sangma and two others.
appeal in appeal,
One,
169, 2000,
169.
169,
One
2000.
six. Lordship, 169. 169, Lordship.
এই এইটো বহি আছে দাদা কিবা এজেঞ্চিত ওলাই গৈছে আহিম বুলি কৈছে কবিতা কৰিবতো কৈছো ফোন এটা কৰক না মই কৰিছো
you are for the appellant in which case? You are not aware,
Criminal, Lordship, 169.
huh?
Criminal appeal, 169,
So
2011.
nobody appears here for already legal aid counsel appointed. Why should we hear you? You have not appeared in none of the occasions earlier. Forget about.
For 9/12/2022.
কেতিয়ালৈকে ফোন কৰিছে কেতিয়া ফোন কৰিছে which state of appointment
Sure, custody appear was a yard dog.
Lordship, kindly say 9/12/2022 order dated.
Why this matter is listed before this court? Conviction and the was under what?
304 part
Part.
two.
Okay, mention. Who is the eyewitness? Star witnesses. Who are the star witnesses? You are also helpless.
My lord.
Then we'll rise. If this is a kind of assistance, then we'll do our whole work will on the basis of evidence will pass judgments. Yes, who are the star witnesses? Eyewitnesses.
I am not prepared, Lordship.
Huh? outside.
My lord.
These people are outside or inside.
Bail out
Outside.
Yes, when he will be able to.
11, other than 2011.
A prayer on behalf of the Legal Aid Council for adjournment is made. Though this matter is pending since 2011. However, considering the prayer matter stands adjourned, as the adjournment stands allowed, and let this matter be listed for hearing on No, 19th. There are other matters, but it will be possible, 19th.
11.
Yes.
Oh, please.
Item 29.
Yes. Mahajan.
Here, my lord, I have tried to reconstruct the file, my lord.
Hmm.
I have the evidence of PW 235
Hmm.
and CW 1, my lord.
What is that? Against what?
376, my lord, 7 years, my lord. He is on bail, my lord.
376, 7 years.
Hello.
He's on bail. Who is PW2?
Who is the victim, my lord? I need the, my lord, PW 1,
Hmm.
4,
Hmm.
CW 2 I need, my lord, and 313 I need, my lord.
Hmm.
Can I take photographs from the LCR, my lord?
This will provide you.
Because
Which one you want? Tell us.
PW 1,
Write it down. PW1,
PW 4,
PW4,
CW 2,
PW2,
313,
313,
and the FIR, my lord.
and the
FIR.
FI. Victim is PW?
Victim is PW 2. Victim is annexed in the petition, my lord.
That is what?
Page 27, my lord. Sorry, my lord, page 21, my lord. PW 2, my lord. Victim is PW 2, my lord.
List this matter when?
Any date, my lord? After a week, my lord.
How many evidence is it there?
There are 5 PWs, 2 CWs, my lord.
My lord, 161 statement of the victim is not legible. Otherwise, I have flag marked, my lord, other depositions PW 1, 2, and 3. But her 161 statement is not legible from the record.
Okay. A copy of the following records I following records be furnished to Mr. Mahajan, learned counsel for the appellant, and also to the learned additional, Mr. P. Bhattakur, learned additional public prosecutor by tomorrow. Okay, list this matter on Monday. 11.
Obligation.
Give the list,
Yes, ma'am.
whatever you want. But don't give a huge list so
No,
that
no,
you
only
are not
PDF,
managing.
code PDF,
Yes,
sir.
yes.
Obligation.
Item number 30, the appeal was expired, my lordship.
Huh?
Appeal was expired.
Now what is to be done?
His senior is not able.
Item 30, my lordship.
No, please tell us your item.
Our item is 30.
Okay, see 30, if he has died,
The
it will abate
They will have to produce the certificate.
certificate. Where is the certificate?
certificate.
Give us. Yes, what do you say? You show the certificate. Yes, these are digital certificates. Yes, show it too. Then we'll close it if they are not saying that will be challenged by legal years or something like that.
Let me verify, lordship. Let me apprise the department that
Okay. Why you need to verify? Okay, we'll verify. Those days are gone. You will verify, will send to CBI, we'll verify it. Give it to us.
the photocopy that is
Where is the original? Original is there?
I'm also.
Well, see, nowadays we'll do it on our own. We'll verify through the office of the health whether this is which office issued this?
Department of Health and
Guwahati.
Guwahati.
Okay. We'll verify because if we give you time, it will be verified. You'll seek a time for 2 weeks, isn't it? Yes. And what about the other case?
Is out of town, lordship, due to some personal.
Who is your senior?
P. Chakraborty, lordship. Miss P. Chakraborty. Lordship, next week, any date, lordship.
Difficult. Very difficult.
Any date, lordship, next week.
Give a notice tomorrow in the cause list. All pending criminal appeal matters. No adjournment shall be granted. And if necessary, court will appoint amicus for hearing. See, from 11:30 you are sitting here doing nothing. And everybody will complain that the courts are not taking up cases. Criminal appeals are pending, first appeals are pending. No judge have time to do this, hear this. MS R. Begum, learned counsel appearing for the appellant in criminal appeal number
249.
249 2013 submits that the appellant has all in the meantime expired and therefore the present appeal shall abate against such appellant. She has also submitted a birth certificate, a death certificate issued by Register of Birth and Death, Office of the Chief Register of Births and Deaths, Guwahati, dated 25/7/2023. Mr. Haloy, learned standing counsel for the CBI, submits that he may be granted. When will be your senior available?
Any date, lordship.
Next week, any date, as per your convenience, we have already fixed matters. Mostly when?
Lordship, last week of November, lordship.
Mr. Haloy,
Lordship,
Please be prepared. We will not have any excuse that if
No.
you have trial or something, you will
Yes.
have to make all arrangements.
no trial,
Because
Lordship.
this bench will be taking up all these old methods. I'm making it clear. 26th of November 2024. Full stop. On the said date, the Mr. Halloway shall complete his instruction. Yes. A copy, give a copy to her. A copy of the Xerox copy of the aforesaid death certificate is kept on record. And Mr. Halloway, Mr. Kotoki has made a submission, some methods. You are for the petitioners and the respondent is CBI. But if you want to arrange, we will otherwise we will appoint amicus. Simple.
14, 15.
14, 15, yes, Lordship.
14, 15, 16. You do either alternative arrangement or we will appoint amicus.
I'll appear, Lordship.
Because you will not be able to appear, isn't it?
No, I was in court number 3, some.
No, that is not the issue. Issue is, it's in series of appeal, I think item number 14, 15, 16, something like that. Mr. P. Kotoki made a submission. This is not for hearing, for orders. We have fixed it for hearings in some date.
I was.
He was the counsel for the appellant, accused appellant. So since you are in CBI, please, if you want to make arrangement,
Yes,
make
yes.
it, or otherwise you will appoint amicus and proceed. We will not adjourn on that ground.
Lordship.
Yes.
When this case was
15, I tell you.
if you fix it.
20.
We have fixed it on 25th.
Okay.
Okay. We have fixed it for 21 November. Yes, next case. Yes. That is gone, I think, 30. Yes. Yes.
There are 32 nearly. 32. Well, just my lord, with all respect, 32 and 33, my lord, pertains to the same case, my lord. Possibly, my lord, 33 was a heart condition, a patient having a heart condition, my lord. For all these 10 years, my lord, no contact, my lord. Regarding 33, can it come after a week, my lord? Even a phone number is not working, my lord. To be very honest, my lord. Otherwise, all trouble will go in vain, my lord.
You take sometimes trouble.
My lord.
Sometimes you should take trouble also without any benefit.
My lord. My lord, then let it remain, my lord. Yes, my lord. But
Yes,
possibly, he has, my lord.
Agarwal, what you say? You are ready.
Ready, because all matter of difficulty to take time.
And take time. See, we know if we take an hearing matter, at best we can find complete 2 matters.
In one day.
One day.
This matter, my lord, with all due respect, is a very big matter, my lord. 32 witnesses, 300 documents are there.
Maybe, but 32 witness, all witnesses may not be so vital.
Not be relevant.
45 witnesses, I have already tried CBI. Almost judgment is ready.
Yes,
Isn't
okay.
it? There are ways and means. See, we'll have to understand those days are gone.
My lord.
That will continue. Yes, of course, we'll go to the vital issues. What are the fundamental points? Why this judgment is bad? Give a date, then Mr. Mahajan also seeking. Maybe one matter, but we'll be able to finish one matter.
No,
is that
yes,
it?
it has to be started. No, it has to
Started.
Once
Today is
started,
day
no, it
one.
takes one day,
Today is
two days,
day
whatever
one.
it
Might be nobody was expecting that this bench will take these old matters.
My lord.
So therefore, a little bit lenient today,
My lord, kindly.
but not
Sir,
from 11th.
My lord.
No leniency.
My lord.
Let us at least finish one hearing matter. Somehow before vacation, we could complete the criminal appeal of 2005.
2005.
Of CBI. How many witnesses?
45.
45 witnesses.
CBI is easy, my lord. 45 witnesses, my lord. They all and sundry they take, my lord. So,
No,
my lord.
not easy, not easy.
No, I'm not saying easy, my lord. No, volume of witnesses that does
The
not.
problem is
signify-
this, you may not read some evidence. You may say that, no, this is not important. I'll skip as a lawyer. But as a judge, I will have to note it down because it's a last court, first appellate, last court of facts. So I'll have to appreciate that. No doubt about this. Don't think that we'll shortcut it. No doubt about that. But we'll appreciate if we go to the relevant, very vital points that these are my issues, these are the evidence. How can conviction may be granted? He will say these are the evidences. Where is the relevance of their argument? Rightly convicted. That's all. We'll mark those part.
2nd of December,
Hobo, anything. I mean,
second of
Yes,
December,
2nd of
December. That, huh?
Okay. Again, as agreed to by the learned counsel for, as prayed for by the learned counsel for the petitioner, appellants, matters stands adjourned and be listed on 2nd of December 2024. You also should look into your diary, please.
Lordship.
Huh?
Now, because of this trading matter, Lordship, I am overloaded, Lordship.
You do some, if CBI cannot say that I am overloaded, I'm not saying about you. CBI cannot put all burden upon you and say that no, old hearing, forget about that. Maybe they are outside, but our sword is hanging upon these people.
CBI is.
And sword is hanging in the High Court itself. All these what not the 2011 matters.
The CBI, all matters are pending, you know.
Hmm.
Those has to be, you know, at least.
We'll try. We do not know whether you people will assist us, but we'll try.
Fine.
At the end of next week, I may be frustrated. No, nobody is interested. Forget about that. Adjourn, 6 adjournment, adjourn.
fine, at the end of the day, I have understood.
Yes. Okay. How many matters it is, please? Huh? Call. Hearing the matter.
That, my lord,
Imagine, what
it is
about the
2 o'clock, as he has said, my lord.
2 o'clock, no?
2 o'clock,
Okay,
my
okay. And other matters, hearing matters, to that admission matters, the leftover matters. Yes.
Permission, my lord, some other day, my lord.
Why?
I am being led by senior.
Oh, no, don't say all those things. Yes. What is the issue here? Why you need your senior?
Big matter, my lord.
No big, no matter is big or no matter is small. How many years conviction? What are the
2
provisions?
years, my lord.
Huh?
2 years.
2 years.
Maximum is 2 years.
Under section?
Under section, my lord, 120, 450, 465, 471, 420, read with section 13.
Who are you? Who are the star witnesses?
Lord, basically, key witnesses.
Yes, ready?
No, Lordship, I'm not. Let him argue.
No, that piecemeal will not do. Mr. Haloy, be ready. Be ready. Today is we are lenient. Be ready.
File is also not available.
I do not know. We cannot adjourn on that ground. Sorry, it may look harsh, but we'll have to. When give a date?
Next. Or last part of November.
Give it done last quarter of November.
29, 29. 26, already one case is fixed.
29th?
29.
29th.
Next item also almost similar allegation.
Okay. While listing this, listing this matter, registry to reflect name of Mr. Haloy, standing counsel for CBI. Yes, okay, we'll come back at 2.
Deeply.
There, my lord, the occurrence is 1/3/2009. And their allegation is, my lord.
Occurrence is?
Occurrence is, my lord.
1/3/2009.
2009, my lord. And the allegations are, my lord, his plot of land by a particular bank, my lord, it was mortgaged and loan was given to a non-existent authority, my lord. As per investigation, my lord. And the amount was 65 lakhs, my lord. With all respect, my lord. Thereafter, my lord, primarily, my lord, several status reports were called for, my lord. If I place the status reports,
Be here. We'll go on dictating.
if-
We'll just go on dictating. Hearing we'll do simultaneously
my
because so that there is no confusion on the facts.
then should I read the FIR?
Be here. Just listen to me.
Imagine.
This is, I think, this is the fact. Then we'll get clarification, everything. We'll complete this matter, that's why. First, we'll say the background, why this, what is the petition. The present writ petition under Article 2 heard Mr. B.K. Mahajan, Learned Counsel, also heard Mr. Spencer. Well, just a preliminary. The present writ petition under the present petition, writ petition is filed with a prayer for proper investigation of Sanmari Police Station case number 81 of 2009 by an independent agency like Central Bureau of Investigation and oblique or Criminal Investigation Department of the Assam, and investigation be monitored by this court. Such prayer has been made fundamentally alleging absolute carelessness and lack of proper investigation to the FIR lodged by the petitioner. And it is the case of the petitioner that by doing so, not only the petitioner's rights are violated, but as a result, his properties are also fraudulently been mortgaged which has not properly been investigated. The case of the petitioner is that petitioner is the owner of Miadi land measuring 2 kathas covered by DAG number 422, Patta number 130 at village Borsajai in the district of Kamrup. According to him, the said property was unauthorizedly mortgaged to secure a loan, fraudulently mortgaged to secure a loan from Silpukhuri branch of the UCO Bank by one Messrs. Canic Enterprise. Inasmuch as petitioner is having no relation with such Canic Enterprise. And in the aforesaid loan, the petitioner has been fraudulently projected to be the guarantor of the loan. Accordingly, the petitioner filed the FIR on 1/3/2009, and on the basis of such FIR, Sanmari PS case number 81/2009 under section 420/468/407 IPC was registered. As the aforesaid loanee, that is Messrs. Canic Enterprise, defaulted in payment of the loan, the bank initiated recovery proceeding against the petitioner, being projected as a guarantor for the loan under the SURFACE Act. SURFACE Act. Full stop. SURFACE Act. However, by an interim order passed in WPC 1986, isn't it?
My lord.
1986/2014. by an order dated 9/4/2014, isn't it? 14, the proceeding was stayed. Full stop. The facts, the further other important facts which are not in dispute are which are not in dispute as well as discernible from the case diary produced by Mr. K. Gogoi, Learned Counsel, the following facts, undisputed facts can be recorded. After lodging of the FIR dated 1/3/2019, during the course of the proceeding, different status reports were called for by this court and the learned State Council has also produced the case diary. From the different status report which are part of this record as well as from the case diary, the following undisputed facts can be recorded. These are the facts now, they will shorten it. The state, no, it was in 2009. Since 1/3/2009, nothing substantially progressed in the investigation. Full stop. The CD case diary went missing, which is reflected in police report dated 30/12/2014 and report dated 28/2/2015. Also in report dated 16/5/2015. On 16/5/2015, the jurisdictional magistrate issued strict instruction to the investigating officer to trace out the case diary and also to submit the final form by expediting the process of investigation. However, investigation, this was ordered at 16/5, na? 16/5, full stop. Thereafter, also, matter did not proceed. And in that backdrop, the present writ petition was filed. Full stop. Next, after filing of this writ petition, and thereafter, this court, under its order dated 16/11/2015, issued notice, and thereafter only the investigating officer recorded the statement of the informant on 7/12/2015. Seven 2015. 7/12/2015. Thereafter, what happened?
Thereafter, my lord, so far as this note sheet by my friend, my lord, it says everything, my lord. Otherwise, my lord, lordship may have a look at this, my lord. All dates are given, my lord.
Recorded. However, just a minute. There is an order 441 2016, something like that. After that, 16-1 is the first order notice, isn't it?
My lord, my lord.
Was there any order in the year 2016? In that case?
16, my lord.
Huh? Somehow, no, there is no order, no?
Yes, my lord. For reconstruction of case diary, it is there.
Where do you got that order?
My lord, 4/1/2016, my lord.
Where do you
Lower
get it?
court below, my lord.
Lower court.
Below, it is in the application, I'm placing it, my lord.
Can you just
Yes, my lord. 4/1, my lord, with all respect.
2016?
4/1/2016. Yes, my lord, it is there. I'm
Is
placing
it
that.
part of your repetition or case
Yes,
diary,
yes.
anything? Just
It is
I
part
want
of
to
the-
quote it.
Case of my lord, 4/1/2016, my lord.
Hmm.
4/1/2016 order to be.
Probably in the case diary it is there also.
Yes, there it is there. That's I'll record it, but just I want to see that.
Yes.
Red mark is there also.
4/1/2016. My lord, it is in the case diary, my lord.
Case diary. Oh, yes, I have got it. The case diary reveals that on 4/1/2016, the jurisdictional magistrate directed the case diary contains an order dated 4/1/2016 passed by the jurisdictional magistrate. The said record reveals that on 28/12/2015, the officer in charge, namely Inspector Hriday Kolita of Sanmari Police Station, prayed to pass an order for reconstruction of the case diary for the reason that the earlier IO, that is SI UC Roy, had expired in the meantime on 3/1/2012 without handing over the case diary. And therefore, the investigation could not be carried out. And the case diary also could not be traced out. Accordingly, the jurisdictional magistrate, by order dated 4/1/2016, directed to reconstruct the case diary. It is seen that subsequently, several notices under Section 91 CRPC were sent to the concerned bank and DRT to produce relevant documents pertaining to the alleged loan. Full stop. The case diary further reveals that the FSL report obtained by the investigating authority authority shows that the petitioner's signature as guarantor in the bank was a forged one. Such FSL report was obtained on where is the date and such of FSL report and dated. Such FSL report is dated.
Dated. FSL report, my lord. It is there, my lord. The IO collected the FSL report of Guwahati. The report reveals the which was admitted. My lord, can I place this order? Prothom paragraph plus.
An FSL entry was made in the CD Lossi on
25/8.
25/8/16.
The FSL report is dated.
Court's order, my lord, reflecting the FSL report, my lord.
It is also available on record. Just like record that on 6/2/2016, specimen handwriting and signature of the petitioner were sent to the forensic science laboratory to compare his signature and handwriting with the signature found on the documents furnished by him for sanctioning loan to the Messrs. Koenig Enterprise. The FSL report was collected. The FSL report was reflects that so and so. Okay. The case diary also reveals that on 2/2/2016, the investigating authority says certain original documents pertaining to the loan from the debt recovery tribunal. On 20/2/2016, the IO was transferred. The case diary further reflects the IO in the case diary recorded on 19/10/2019 that IO did not found any office by name of Messrs. Koenig Enterprise. Subsequently, on 5/4/2024, final report number 109/2004 was submitted by where is that? Where do you get that?
Yes, my lord.
Huh?
Possibly, my lord, kindly ask him, my lord. My lord, that newly joined sub-inspector, my lord, what the term to be required? Probationary, my lord.
Also.
Maybe, my lord.
See, I was transferred on subsequently. I was transferred on 5th. I'll just correct it. Just I'm recording the fact. On 15/10/2019, and subsequently, new IO was handed over the investigation, and admittedly, such IO was an probationary.
My lord, that word P is, I do not know what it stands for. He has to clarify, my lord.
Okay, probationary was just bold unlike a probationary officer. Okay, now from the aforesaid facts, admitted facts, the legislative approach and of the investigating authority is writ large. First of all, the FIR was registered on 1/3/2009, and the statement of the informant was recorded after
6 years.
6 years of lodging of such information. The case diary was lost in between. It was reconstructed in the year 2016.
Right.
And apparently from the case diary, from 2009 to 2016, nothing happened. To 2015, nothing happened except recording of the statement of the informant. The investigator got a little activated on issuance of notice by this court. And it is interesting to note that and this court cannot but record that this court has not seen any sincerity of the IO in proceeding the matter, proceeding with the investigation, proceeding in the investigation, in as much as simply issuing notice under section 91(1) CRPC to the bank for production of relevant documents, the IO did nothing for proper investigation. Inasmuch as the fundamental allegation is commission of fraud and impersonation, and therefore it was very important for very important to record the statement of the complainant as well as to send the specimen signatures and handwriting to the forensic science laboratory, and such such action was done only in the year 2016, that is after almost more than how many years?
No, 2012 or so, 7 years.
7 years from the lodging of the information. The fact also remains that the investigator concluded that there is no entity called Canic Enterprise. It is also an admitted fact that the forensic report suggests that the signature on the basis of which the guarantee was created is alleged to be not of the person who is shown to be guaranteed, who is shown to be guarantor, that is the petitioner. And in the process, the petitioners land was required, land was sought to be proceeded under the SURFACE Act. Even after finding of the aforesaid material, that is under materials, that is the statement of the victim, that is informant, and the opinion expressed by the forensic expert are taken at its face value. In the considered opinion of this court, a prima facie case is made out as alleged in the affair. However, the investigating officer has proposed Where is that final report? Huh?
Lossy may also indicate.
We'll indicate. Just these are the fundamental plain thing. We'll hear you. Just I have recorded.
One level of bank people were not even
4, 5, and 6. Point number 4, 5,
I'll
6,
come
and
to
7.
that.
4, 5, 6, and 7.
Come to that. Where is that final report?
Final report is flag mark is there also.
Flag mark is there. Second.
Later to the court I have placed, my lord.
That you have seen. No investigation.
Final report on lordship 25/4/2024.
Final report on
25/4/2024 lordship.
Submitted a final report for the reason that Messrs. Kanika and that there is no entity called Messrs. Kanika Enterprise. If Kanaka Enterprise, though it is established that the signature of the informant was forged. If that be so, the investigating authority ought to have investigated in the bank how a mortgage was created and oblique or how a loan was sanctioned and transferred in favor of an non-existent entity. However, unfortunately, none of the bank officials has been examined or statement of any of the bank officials who were connected with the sanctioning of such loan in favor of Messrs. Kanika Enterprise, according to the Kanika Enterprise was granted. Therefore, this court unhesitantly views such lacuna to be a glaring lacuna on the part of the investigating authority, and this court is compelled to record that such conclusion and such mode of investigation has been done for reasons other than bona fide. The law in this regard is well settled that now let us come to the law. Well settled that ওপৰত আপুনি লিখিব लेकिन this is the facts na ওপৰত তাৰ আগত আপুনি then we have come in the aforesaid backdrop now right here, Mr. Mahajan, learned counsel, argues that there are glaring illegalities in the investigation and therefore this constitutional court in exercise of power under Article 226 of the Constitution of India can very well direct a fresh or de novo investigation even after the closure report, inasmuch as from the material available on record which are not in dispute, it is clear that the investigation has not been conducted in a proper and objective manner. In this regard, Mr. Mahajan relies on the decision of the Honorable Apex Court in Nitu Kumar Nagyas versus State of Rajasthan and others, reported in 2020 16 SCC 777. Referring to the judgment of Honorable Apex Court in the case of Pooja Pal versus Union of India and others, Mr. Mahajan further contends that further submits that which paragraph, Mr.
78, 79, 81.
Further submits that the investigating authority are absolutely biased and they have shown their incompetence, and therefore this is a fit case where this court should exercise its power. And therefore, this is a fit case and is a case of rare and exceptional nature for which this court, in exercise of its power under Article 226 of the Constitution of India, should transfer the investigation to an independent agency so as to instill confidence in public mind. Full stop. Inasmuch as according to him, the present one is an exceptional case, and the efforts and the lackadaisical approach of the investigating authority has been clear from the material available on record. Full stop. Okay. Mr. That will do. That much will do. Anything you want to add?
My lord, one would be possibly, I may be wrong, my lord, that, my lord, the state and Union of India, my lord, this, my lord, with all respect, my lord, where, my lord, only one paragraph, my lord.
Which judgment?
This one is, my lord, with all respect, my lord, because in both
Okay,
sides
okay, no,
agree.
no, don't be so hesitant. We
I'm
are
sorry,
here
my
to hear you.
My lord, Mandakini Diwan.
Mondakini Diwan. Okay. Referring to a recent judgment of the Honorable Apex Court in Mandakini Diwan versus High Court of Chhattisgarh,
Para 11, my lord.
Mr. Mahajan. Contents that. No, that will record him. That will record him. Then
My lord, 4.8, my lord.
4.8. Paragraph 11.
Paragraph 11 and primarily 4.8, my lord.
Paragraph 4.8.
And 11 is the, my lord, ratio, my lord.
Page 8, Lordship.
11 is the ratio, my lord.
Huh?
Internal page 8, 4.8.
Eleven is the ratio, my lord.
Eleven.
When both sides agree, possibly, my lord.
No, that is why we'll first record his,
Okay,
then
yes.
we'll. That's why I kept this for.
Yes, yes, yes. As your lordship pleases.
Anything to be added?
Other option not necessary.
That more or less same.
Exactly the same. Only thing, lordship, there will be then law.
No,
my lord.
that this part will. Yes, you are.
Because, my lord, there is a normally a feeling, my lord, when final form is submitted.
No, that will explain.
That, my lord.
That part I will explain in my judgment. More or less, I have registered recorded the fact. And now I will record both of your argument. Then I will do the rest part peacefully in my chamber. After this part is dictated.
I have understood.
Type.
Then it will be ratio, my lord.
Yes, that ratio. So therefore, I will keep it safe. CV. I will deliver it on Friday or next Monday. Yes. Mr. K. Gogoi, you are as appearing as learned additional senior government advocate. In his usual fairness, submits that after going through the case diary as well as material available on record, the state will not object. State will not object for an independent investigation in view of the material available on record, more particularly for the reason that even after the receipt of the FSL report and even after conclusion by the IO that no entity like Messrs. Kenyak is existent, the investigating officer has not attempted even to record the statement of any of the bank officials, which are very much necessary in as much as the matter intrinsically involves the bank authorities and its officer, as the entire offense was committed in creation of a mortgage and sanction of a loan, admittedly to an institution which projected by the IO to be non-existent.
Exactly,
Projected by the IO to be non-existent. Full stop. Full stop. This court has considered the rival arguments of the learned counsel for the parties. Hearing concluded, judgment reserved.
Highly obliged.
This is, see, Mr. Mahajan, what I will do is, this part he will type, then it will be easy for me to go through that and dictate, and if necessary,
As your lordship pleases. As your lordship pleases.
Just I'm keeping the case diary. If necessary, certain which can be disclosed, I will quote unquote that forensic report and.
My lord.
But we'll have to make some observation against the IO.
Recent
Are you-
Honorable Punjab and Haryana High Court also.
uh.
That part Lossi may.
Can you give that,
Lossi,
give,
I will.
you give it by tomorrow?
I will provide.
Huh?
Lossi.
And we do not know as on date, but if necessary, we'll have to make some observation against this kind of investigation,
yes.
and we may have to invoke the Director General of Police and communicating his order that how it can happen. Let him have an
Then Lossi,
independent
they will take a monitor Lossi. Otherwise,
monitoring, and they let them enlighten this officer. Is it the way to
Lossi,
investigate?
Lossi, Lossi.
The bank, he ought to have seized the documents from the original creation of mortgage from the bank.
Nothing was
The
done.
officers who sanctioned this loan,
Right.
who presented before them, who signed before it. This ought to have been the part of
Nothing was done.
investigation.
Nothing was done. Even
Because it is non-entity.
Lossi.
So it may so happen if it is a non-entity, either to save that non-entity, he has done it.
Lossi.
Or then bank will say, no, this is not a non-entity. He has paid the loan. He has appeared in the DRT. Then
Nothing was done, Lossi.
My lord, despite pendency of the application in the High Court,
Lossi.
how much? What was the amount of loan?
65 lakhs,
Then
Lossi.
so
highly available. Thank you.
Lossi.
this is just preliminary. We have
My lord.
yes.
Lossi.
Is KP Pathak is list this matter on the prayer of the Learned Council for the parties. List this matter on next. When is his marriage? 25th. Give after a 25th date. 3rd of December. That's all. Next week of delivery.